Hello and welcome back to our channel. Today we will discuss about newly notified data protection rules, which is part of DPDP Act, which are basically India's privacy laws and are should be implemented in 18 months time frame by the concerned entities. We welcome again Annindya sir, who has extensively worked on data privacy related projects throughout his career with banks and regulators. And in fact, notably, he was involved in setting up the CERSAI architecture with the National Housing Bank, the housing loans regulator, uh, where all the regulated financial institutions are submitting KYC data on a regular basis on their operations. So, welcome back, sir, and none other than like you to discuss on this topic.
Thank you so much for having me here, Rajiv. Very nice to be participating with you. And these are interesting times. Our entire legal thread work and the entire fiber of the play of law in the country is undergoing a significant change, and so these are interesting times. So thank you for having me over to discuss this with you.
Great, sir. So, sir, you know, right? So, the DPDP rules were recently notified, I think around November 15th, 13th to 15th, if
Yeah,
I'm correct.
so I think 13th, if I'm not wrong. Yeah.
Yeah, 13th. And so they have put a time frame of 18 months for the concerned relevant entities to, comply. Now, so firstly, what is the sense you're getting from the legal fraternity about the privacy laws, right? How they are comparing this with the other, regimes, privacy laws in different in locations. Let's start with like, what is the sense you're getting from your conversations uh, from your from the legal fraternity?
So a lot of people are talking about it, from the people in the department who were involved in making the law to a variety of lawyers who have been entrusted or who have been involved and have been working around this for quite some time. The judgment came way back. The law took some time. We had variants of laws coming in, and then finally the rules are here. And as you've rightly said, the critical part of it gives us about 18 months to get our act in place. Although the authority is already there. In fact, in terms of this, the immediate actionable is the board comes into place, and in 12 months' time, the consent managers come in, and thereafter in 18 months, the fiduciaries are expected to be in complete compliance of the requirement of the law, and which is also akin to what the global structure was. When GDPR came in, it gave a lead time, and that was like the basis of all the evolution of this law, and we always go back to that as like a basic metric. But so happy to see that our law is very different, is simpler, does not create a hierarchy in the nature of information. It creates a hierarchy in the nature of institutions, but in the nature of information, it keeps everything at par. Possibly resonates the feeling of the judgment and also how it should be. I mean, it should not really create a hierarchy. Anything which identifies me some which way, I'm protected, and that is a beautiful concept. It doesn't create any distinguishing feature in the nature of information. It just has a very simple approach to it. And in the center of it, at the heart of it, you have the individual. And
Yeah,
interestingly enough, uh, we call her the principal. So
yeah, data
principally,
principle.
if there's a play of words here, so principally, it is about the individual and not a data subject. And I thought that was the beauty with which they distinguished it. It said so much of the intent, the purpose, the way, the focus of this law, that it is not treating somebody as a subject matter, rather
Yeah,
than keeping the individual, the customer, the client at the center of this entire discussion. It is empowering the individual. It is also retaining the focus. And similarly, if I flip it over, instead of a data processor, of course, there is a data processor, but you have the concept of a data fiduciary,
Yeah.
which essentially is an entrustment that I'm trusting you with something which is mine. Please
Yes.
keep it safely. I think that is a masterstroke, and you don't need to be a lawyer. It just gives the intent and purpose of the structure, the thread, how the law has come into our country, and considering that we are doing significant work in the entire data framework, so to say, in the IT framework, the kind of you see what the UPI has done to our country, where the kind of transactions that are done, we've moved significantly, tremendous strides. So I think this whole protection being centered around the individual is a classic thing. It's beautiful. It just says so much more than, I mean, just by the use of these two words, to me, it just laid out the context threadbare, that how should we all, as practitioners, or also individually as data principals, be aware
Yeah.
that what is the extent of the protection that we are enjoying, and what are the responsibilities in that entrustment, in that fiduciary capacity. There is a degree of trust. There's a responsibility. The law talks of the responsibilities. It says what the data fiduciary is supposed to be doing. But these two words, I think, really distinguish this law from any other law that I have been acquainted with across the globe. I had the privilege of working on the GDPR. I had also worked on the Singapore law. I had some reference of the California privacy law as well. But that's where I see that it's a masterstroke, if you ask me, the way they have laid out the context without emphasizing, with the way they have kept the Aam Aadmi at the center of it, because he or she may not really know that what are the things that I need to do. So there's the corresponding responsibility that they have cast on the data fiduciary. It could be
Yeah.
significant, it could be small.
Yeah.
One which is significant has to have a officer, etc. I mean, we don't need to get into the nitty-gritties of it, but that's the beauty of the law.
Actually, even as a non-legal person, when I read the act and rules, I could, clearly understand the intention behind the legislation, right? And who can also connect that these are more, definitely inclined towards a protection of the privacy of the data principles, right? So very clearly focused on that aspect, something which is you rarely get to see, right, in Indian legislations, right? Such clear thought clarity in terms of implementation of the
No,
rules.
the laws are very clear. In fact, things have improved and simpler usage of language. But it is here that the focus is absolutely bang on. You don't need to assume or imagine
Yeah.
anything. It's
Yes.
bang on. It's on the face of it. It's simple, clear, exactly the way they expect the notice to be. The consent, simple, clear, unambiguous. It's
Unambiguous.
that's the beauty. I think when I was also reading that, one is that I have the right to get an eraser of my data once it's not being used. In the same vein, in the same thread, they've also cast a responsibility on the fiduciary that should this data no longer be required, please erase it.
Please erase.
So, from the obligation to enforce a right, that I have a right, I have to enforce it, I am obligated to do certain steps, it is flipping it over to a certainty that don't
Yes.
worry, after the purpose has been dealt with, you're safe and secure. I don't need you anymore. Your data is, purged some which way. I'm assuming all of that will happen. But that is the beauty of the language. That one, yes, you give the person the right. You keep a caveat that, yes, in case there's a legal purpose for which you need to, keep the data for records or whatever, there's money laundering, etc., etc. There's an interplay of various other laws. But at the same time, they're saying that the moment you think you know that the processing is done with, please erase. It
Yeah.
takes me back in time when I dealt with a particular matter where an institution was sitting with some old data points of individuals who had taken a particular service, and that had, I think, about 2 or 3 years had since lapsed. and they wanted to tap this bucket just because they had the privilege of sitting on that data to reach out and sell further goods and services, bereft of the fellow knowing, wanting any kind of further communication. So from that, and I remember I had red flagged that journey and said that this may not be a very appropriate thing to do because the I'll not say data subject anymore, but the data principal possibly did not wish for that to happen.
Yeah. Interesting points. Yeah, we'll come to this. The relevant parties involved, like data fiduciary, data processor, data principal. We'll get into deeply in that. Uh, if you could briefly explain how did we come to this point, right? What kind of judgment we had? What were the trends in the country? What were the instances, which kind of led the government to,
So I
come
would
up with these
assume, you
laws?
see, the law was there in the
Ah,
IT Act, the laws were there.
yeah.
The respective sectoral regulator had given a variety of legislation in which the protection of data was available. The regulators, RBI, NHP, IRD, they had given a lot of regulation in which they had insisted on protection of data, the privacy aspects, time and again reiterated in umpteen number of master circulars. But I think what the judgment did was made it a fundamental right. So, as
Okay.
against another sectoral regulator looking at it, there is a piece of legislation which comes and addresses the issue on a standalone basis. So it shows a significant change in the approach, that it is
Yes.
not something ancillary, but now a fundamental right, courtesy our judgment, and has to be dealt with separately, sincerely, and with utmost responsibility. It is not something which is an add-on, but a standalone piece which has to be addressed by one and all. And as much, we are talking of this, the consent architecture, that, fair, clear, unambiguous. Individuals or data principals also need to be mindful that once you have given that consent, please understand, the beauty is that once you have given that consent, thereafter, the malice on the other side has gone, if at all there was any. But you really can't take up that argument that there was an intent to do something malicious with my data. If you have given that consent, then you have to be very mindful. So, this is a law which is only looking at these two aspects. It is saying that what, as an individual, you are expected to do, you need to be mindful of the law. It is telling the fiduciary that please act within the purpose set that you possibly have. There's a goods, there are services, whatever you're doing, there's a commercial arrangements. But yeah, be in that block. Don't traverse beyond.
Yeah.
So I like the way the focus is suddenly on this aspect only. It doesn't talk of something else and then says that, okay, be mindful of data. So there's
Yeah.
a shift, there's a paradigm shift in this. And this approach is again uh, customer centric, individual centric.
Yes. Yeah, and as you rightly said, the data principal cannot back off right after giving consent and cannot raise litigation, right? Like
I would
with
assume
yeah,
this is just the beginning, and not even the beginning, 18 months from the beginning. But I would assume that if I had given a consent and it goes through all the parameters that has been laid down in the law of being clear, precise, fair, unambiguous, specific to the purpose, etc., etc., I think then as a fiduciary, there would be a degree of protection also coming in. As much as we have seen a lot of data, there's another point which takes me back to your question is that we've seen the biggest of names where there have been data breaches.
yes,
You talk any the biggest of names, not only in India but abroad, even Google's of the world, they've faced this. Even the
yeah,
secure environment of Apple, we have seen something. Similarly, in India, the variety. I think Facebook had a huge issue with
Yeah.
data going to the uh, dark side, so to say,
Dark web.
dark web, right? And you and I would not know what really has happened.
Yeah.
Uh,
We
we
had a
only get
recent.
to
We have a
know.
recent. Yeah.
I'll just finish this because you see,
Yeah.
you and I would not get to know.
Yeah.
The enterprise would have known. We would get to know later by virtue of a news report or an action by some authority. Look at the law today. It says there's a breach. First and foremost, please let the guy know, the person know. Data principal, your data has been leaked. Give some basic information immediately. I would assume that they also expect that the data principal will be mindful of his or her data, do a change of password or change of something or the other to minimize the loss. And thereafter, it says that, okay, in 72 hours, please do XYZ. That what is the thing happened? How can you minimize this going forward? How will it not repeat, etc., etc. It
Yeah.
just is a complete different narrative that we are seeing in this law.
Interesting. And in fact, we have one recent example which we will talk about of data
Sure.
breach of one of the banks. It's well known, which came was reported in media, right? So we'll try to connect like how players fall in and where are the obligations for
Exactly.
better understanding.
No, no. So these are many examples, and these are impacting your and my daily lives. I bought a car, a decent vehicle of a particular threshold value. The next I know, I am flooded with calls and messages that you have bought a car of this kind and on so and so place, on so and so time. You are entitled to a loan.
Yeah.
And lo and behold, what has happened? And you realize what happened, that you give your data somewhere because somebody would be putting up the forms and filing in the data with the authority, and that data has gone. Basis and the, I don't know whether one should say, the arrogance with which they are saying that, we have procured your data from there without your consent. We are not interested whether you want a loan or not, but I'm telling you, I'm doing this.
And yeah.
You and I are sitting on a food delivery app, right? You are ordering a thing of your choice, and suddenly you get a pop-up. There is a credit card for you. What has happened?
Yeah.
The food app, you never went onto the food app with the intent of buying a credit card. You wanted to buy food.
Yes.
So understand the background, what happened here, what transpired. And
And
all
it's
because there was one opaque statement which came when you signed up. You would have filled in the form and you would have said, okay, okay, okay. And lo and behold, this is what is happening. This is what's coming your way.
there's a lot of such scenarios which needs to change, I think, in India, right?
Absolutely. Absolutely.
Uh, uh, it will be quite a journey for the the participants. And actually,
Yes.
coming to participants, let's clearly explain who are the participants as per the DPDP Act, right? So, who is a data
Sure.
principal, the fiduciary, data processor, and consent manager? If you could briefly, touch upon this.
Sure. So, as I said, the data principal is a person like you and I who is wanting to avail the services of some enterprise for the purchase of a good or some service. So, I have to give my data, basis which I expect that I will be given that particular service. So, this is the individual, and that person, in terms of the law, has to give a proper consent that yes, I'm authorizing you uh, to use my data and to process my data so that I'm entitled for the service that I'm expecting from you.
Sure.
The person with whom I'm sharing now, it could be someone who is a small enterprise or a large enterprise. I would assume in a smaller enterprise, the data fiduciary and the data processor might be the same. But in larger enterprises, they will possibly be taking in all this data and also appointing certain smaller players who would just do the processing and cull out what is the relevant piece of information. So these are these third party entities who are the processors. And between the first leg of the journey, there would be enterprises who are managing the consent flow. That, yes, I'm authorizing so and so person to log in, take my data only for that purpose. So the consent architecture is mapped. All these pieces sit very well, are very fine, but it is in these pieces only that the data breaches happen. So thankfully,
Okay.
as a fiduciary, I'm sorry I'm coming back, but data fiduciary, by the use of the word fiduciary, is also made responsible of this data processor, because the data processor is not acting independently. It is acting at the behest of the fiduciary. The principal never approached the processor, approached the fiduciary. So to that
Yeah.
extent, the fiduciary is like the responsible entity for all actions to be undertaken not only by the fiduciary but also by the processor appointed by the fiduciary. So there is a bilateral agreement that is expected, and I'm very certain that and very mindful that this agreement will also be subject to legal scrutiny at some point in time at various organizations, and the larger organizations will be extremely mindful about the kind and type of people who are engaged in this activity, and that they also have adequate security thresholds so that the data principle is again, dealt with in with a net of safety and not mindlessly.
Got
So these are the principal players. You have a board in which there's a grievance redressal,
Yeah.
uh, but then that is like at a higher level.
And
At the individuals level, at the data principals level, these are the three enterprises that would have significant impact. And of course, there's a hierarchy in data fiduciary. There is something called a significant data fiduciary, where the volume of data that is being dealt with, I guess the thresholds would be higher. But I'm assuming any large enterprise, any large bank, anyone which has a significant presence in the country, any insurance, any hospital, any entertainment, I'm assuming that all of these people should get covered, would get covered, because of the various experiences that all of us have had in our capacity as individuals, in our day to day life, where all we have seen data moving mindlessly without
yeah.
our any active participation. Like in the example that I gave you, I bought a car and somebody was selling a
Yeah.
loan to me. So it's that mindlessness. I'm very certain will get culled out as these players fall within the realms of the law.
Good. Let's talk about the data which is identified as PII, personal identifiable information, right? Which is the core of this act and rules. So, what kind of data would be considered as PII, and which and how it should be collected by consent, managers? If we can, yeah, talk.
Yeah, sure. I the way the definition is that anything which identifies me, my email, my mobile, there are a variety of my name, etc., etc. That is the data set, and I need to be very mindful in the sense that when I am a data principal, that what is the data that I'm giving. Similarly, before we come to the consent manager, the data fiduciary is also asked that only seek such data that you require. There's a purpose and there's a concept of minimization. Today, if you want to open anything which is basic, the kind of data that is asked for is humongous. Not all of it is required. Uh, at times, that extra superfluous data that we are giving, and we are more than happy to give it away. We are not conscious enough as principals, but as fiduciaries, because the same person is doing the job of a fiduciary at some point in time in life,
Yes.
acting as a principal in some point in life, and there
Yep.
is an inherent dichotomy. So anyway, but as a fiduciary, you have to be asked, you have to be marked. I think each form that you and I fill at various counters, I think each data field will now be mapped to a specific purpose. Now, if you digitize it, maybe you could have things hovering while you fill in a data field. And if something is not required and you're not able to answer as a fiduciary to yourself that why am I asking this data, is it really required? And there are certain illustrations which are given in the law itself, which really say this and magnify this point very well. So I don't need to get into it. But that extra data, which is a burden on everything, it's a burden on the infrastructure also. That if you have something which is superfluous, just
Yeah.
dump it. So I think that is the way both the sides will get mapped, and there'll be a consent manager who will be holding this. It's like I'm assuming it'll be very similar to, say, your that DigiLocker kind of a thing, where you go when you are using a DigiYatra, you give authority to the DigiLocker to share your data for that limited purpose, and when you're walking into the airport, they just do a quick check of your credentials, and you are through and through. There is a use case, there is a ease of that particular process, and there's also an ease with which this entire thing happens. So I'm assuming that the same concept will get replicated. It'll be the same ease with which the consent manager will come in, ask for certain credential checks upfront, and to that extent, whatever data the principal is going to authorize will get shared, and whatever needs to be pulled in, it's only that which will get pulled in, nothing more. And each such data field will be mapped to what data you're asking. You can't really have data that you think like I can ask anything under the sun and be done with.
Yeah. And
Like in a hospital, sorry,
yeah,
I'm just taking half a second more. Like, when we walk into a
please.
hospital in any OPD or the kind of forms that we fill in, uh, you should possibly ask me my name, my ability to pay whatever you expect me to pay, my address, fair enough that you need to get to me, but that should be it. Look at the kind of fields that we fill in. And see, another aspect of this law is that it deals with digital personal data. So all these forms where we have filled in our Aadhaar, again, without the ability to say much, all that goes there, it is not masked. It gets uploaded onto a system. I think all these journeys are going to be revised, reviewed, and which is why I personally feel, and I've spoken about this when the law came in, there'll be a concept where enterprises, now we all talk of KYC, which is know your customer. This journey will move on from KYC to KYD, which is
Yes.
know your data,
Very interesting. Yes, sir.
which means that, and this will have two aspects, this will have two facets. One is you and I, as individuals, will need to know our data. What is the authorized use that we have given? What is the handle that we have given to someone? When should we pull that out? So that we are conscientious about our own conduct and we are mindful in which our data is getting used and utilized. Flip it over. The data fiduciary will now need to, understand their entire customer data journey. What are the points? I'm getting data from point A. I need to do processing of a type with one processor. So that's another journey. I need to do something else with someone else. And typically, say, like in the bank, BFSI, there are many such people where the data gets shared. So I, as a mindful organization, as a data fiduciary, and if I'm assuming I'm a significant data fiduciary, I will have to map the data journey. And that is the KYD. Know your data. Where is your data? How is it sitting? With who all is it sitting? What are the contracts underlying? Is there a reason for this data to exist? Am I done with this data? Do I need to process this any further? Has the consent given me that empowerment to deal in that data in some which way? So I think it'll be like how you and I hail cabs. The cabbie gives us a score, and you also give the cabbie a score.
Yeah.
So this KYD, the know your data figure, will reflect against an organization if I had it my way. And that will entrust me as a data principal to share and conduct my affairs with such an enterprise where I know they'll not mindlessly deal with my data. So in today, when you see cross-selling, upselling in a life cycle journey of a customer,
Yeah.
and you want to cross-sell everything forcefully, I am assuming that there'll be a paradigm shift in this. And instead of force feeding, there'll be an entrustment, which is why I rely on the fiduciary word significantly enough, that I'll be happy to share my data with a particular conscientious organization, because I know that whatever I need, they will only process to that extent and nothing beyond. So I will rate them very high. And should I need anything further, and I know they are providing that kind of service, I would assume that as a data principal, I will first go back to that same data fiduciary.
So kind of challenges you have, touched upon in the transition, right? We have to, we are looking at. Do you think it's possible for, all the entities, all the relevant, concerned parties in India to rewire the systems, and retrofit with privacy controls and in 18 months? Do you think it's possible? It seems like a very humongous task in India, right? Where, like you mentioned correctly, mindlessly data has been collected by various organizations. Healthcare is one big example. BFSI is another example, right? Where so many of our documents, which has PII data, has been scanned and lying, in clouds, in servers, digitally. Do you think we will be able to tackle this challenge in 18 months, or will there be, or do you think or do you see for an extension?
I sincerely hope not. I'm a perennial believer, and optimistically, I would sincerely hope, considering that there is a lead time, and more or less the industry was expecting this to come in place. The judgment came back in, I think, 17, if I'm not wrong, and that became a fundamental right. That protection, the act came in. We've got, I think it was 2 years ago. Now the
Yeah.
rules have come in. It allows another 18 months. I I sincerely hope that there's no extension. And I also believe the kind of penalties that this law is talking of, we possibly have not seen those numbers. And as against a percentage of the global turnover, as the GDPR says, this has very pointedly looked at 250 crores, which I think should be incentive good enough for people to expedite wherever they have not expedited. And
Yeah.
I'm glad that these numbers are not 10,000 or 2,000 or 5,000 per day, or with something. I mean, I'm so glad to see a very serious number, which will remain serious for some more time. It is not that today it's a big number, tomorrow it's going to be a small number. No, it's a significant number. It also indicates the underlying urgency and the criticality of this aspect. So I'm assuming that giving 18 months is not small time, and we have done some significant work as a country. I always go back to the UPI example. What we have done is like a roadmap for the entire universe. I think the entire globe is trying to do something or the other of that kind and type. And we have been leaders in that innovation. So I don't see why, if we have done that, if we have done a Digi Yatra, if we have done a Digi Locker, why should this be any different? Why should this be that big a problem? We have dealt with data. We know how to deal with data. And the reason I again quote UPI is because that is absolute money. That is your and my money being dealt with real time. And it's faster than whatever we could have imagined. If our country can do that, and if that is real
Then
time, then why not this? I am very certain the platform is there. And I think there's a lot of seriousness about it. I think whatever little that I've heard of all the people from the respective ministry talk, there is a lot of seriousness, and I'm very certain that they have already thought this through, and which is why 18 months. They could have given 12 months, they could have given 6 months. But when they're giving you 18 months, I think they're giving you adequate lead time to
adequate.
fall in
Yeah.
place. And you see, this is not like every significant data fiduciary is a global organization. It's no longer a person who's only restricted to India.
Yeah.
Any large bank has some operation which is abroad, and I'm very certain this level of protection has already been made available. It is just that the same architecture has to be replicated here. And believe me,
So,
I feel just one more second there, but Rajiv, I really feel that certain aspects of GDPR are stricter and tougher. While we'll not discuss that today, this is a very simpler and a very clean legislation that way. Customer at the center of it. I am giving you authorization. Please use this my data of this kind and type till such time you need it, or till such time the law requires it. We're not touching upon the government schemes and all. There is a method to that as
yeah,
well. They have
that's what I
also
was
been
saying.
entrusted with a similar sense of responsibility. But I understand we are a developing nation. There's a lot of support that needs to be given to a certain section of the society. So there is a slight relaxation to enable the government to process data to that extent. But if I step away from that aspect, then I think it's a very clear journey. It's a very clean journey. It's a very simple law. It's very clear that this is the set, this is the ask. The moment it's done, contract is over. There's nothing else over. Be done and
Yeah.
dusted.
So what you're, I think you have used this term, know your data, right? So what you're,
Yeah.
uh, let's say, working on or proposing is overhauling of the current KYC, framework in the country, and do you think there's a need for overhaul and come up with
KYC will
something like,
continue. KYC
okay,
will continue. And like the alphabet, KYD is something which follows KYC,
yeah,
and KYD will encapsulate KYC. It will be the larger framework in which KYC will be a part.
okay,
KYC is just the onboarding that, yes, you've got a customer. There's a PMLA requirement. It comes from the FATF that, yes, identify, accept. And now that our law has also undergone a change, there are certain aspects there. But this is a step further forward, while having KYC as an integral part of it, but being mindful of that journey, that once the customer is onboarded, what are the touch points? How is the data flow happening? Where all is it going outside the organization? Where all within the organization is it staying? And how long does it need to stay till? All
correct.
these aspects is the KYD.
For which industries you think it will be a very big challenge to in the next 18 months to comply?
Like all industries, I think it's a very fair thing. See, banks for sure, BFSI,
Yeah.
and hotels. I mean, you
Oh,
just
yeah.
give data, right? You just give data, and we don't take it back. And you see, they also have a problem set because they have to be extremely clear about who's coming in,
Yeah.
and there's a legal compliance. Similarly, healthcare. I would assume that healthcare will sit at the center of it. I
Yes.
also hope that with this digitization, all the forms that we need to fill in will be significantly reduced, and we'll not spend as much time on those counters and those lines filling in a thick set of papers, often giving much more data than what's required. You'll possibly need to know whether I have an insurance or not, and the consent manager will give you that relevant piece of data. What is the extent to which I am protected, and what is the open exposure, if at all one may say so. Similarly, in the bank's journey, you will need to know what is the extent of data that you need. You may need to know. See, if I'm giving money out is one thing. If money is coming in, then I need to be mindful of money laundering. That it's a clean source of income which is coming into me. I should know the
Yes.
source. I should know the identity, and that's it. I don't need to ask anything further. If I'm giving a loan, yes, maybe certain other things may need to be asked. But the concept of minimization at the heart of it will really give a sense of semblance that that overdose of data is will possibly cease to exist. I'm very hopeful of that. And
To
we are
put it
also very,
in,
very carefree in giving. Like we all carry our Aadhars and PANs, and before a banker is going to ask, you're happy to first give it away. And after that amendment happened, where like in the registration, you can't use a Aadhar any longer. So I
yeah,
still see so many people who are very happy to give the Aadhar, and then only to realize, oh, this is no longer acceptable, so please take it back. And then they're lost that, what do you do? Now you need to understand that the Aadhaar is so much more, and it's connecting so many more dots. And here there is one particular person who's saying that, listen, please do not give me the Aadhaar. So I think that
Yeah.
concept, that consciousness has to come in. As I said, the KYD aspect has a side which looks towards the data principle as well, and that mindlessness will possibly cease to exist. It'll
Yeah,
take time.
it's a long learning curve for data principles here in India, at least, right? Uh,
Yes.
and in fact, recently there have been changes by UIDI, specifically
On
like
the physical Aadhaar, yeah.
physical. Yeah, it's a very good change,
Yeah.
welcoming change, right? Where now these organizations will have to implement a system of verification. Though that means they'll have to tie up with, verifying, entities, right? And not just collect and keep the record. They'll have to first verify, and then also they'll have to adhere to the DPDP, rules and purge the data when the purpose is
Yes.
over.
Purpose. Or you just transfer the data. Maybe there's a repository somewhere with some government
Yeah.
institution. Pass that data, purge it at your end. It can be retrieved at that entity. I mean, given a choice, I would put up a Digi Yatra anywhere and everywhere. It's beautiful.
uh,
I mean, it solves the purpose, minimalistic data in your control, and eases your life.
there's purging also happens, like in the back end. So you're very clear, like what is going to happen in the whole
I
flow.
hope so. I sincerely hope so. And I hope everybody has that clarity.
So one interesting, example I want to talk about. Let's say a loan service provider is calling me. He has my number, because of legacy issues, and then he's like suddenly asking me, "Do you want this loan?" Now we have DPDP routes notified.
Yeah.
Now,
Yeah.
what kind of conversation, we will have with such entities?
I sincerely hope they'll cease to exist and it'll not be like the DND register. Just one sec, sorry. It'll not be like the DND register where, it possibly still doesn't help us today. You and all both get, you and I both get all kind of those pesky calls, and that is what we are dealing with here. But thankfully, the fiduciaries are also cast an obligation to go back to the existing set of clientele and tell them that, this is the data, this is the usage, this is the purpose for which I'm going to use the data. So, hand on heart, it's a beautiful thing. The processing, once it's done, there's a retention. The retention has to be backed by a legal purpose. Once that purpose is done with, retention is also only for legal purposes, and that's it. You can't touch the data. It's out of bounds for you. So this aspect should die its own death. The law should have
Sure.
come to us much earlier, and ideally all of these things should fall. And thankfully, that 250 crores should be a very good deterrent. I'm very
Yeah,
happy
it's
to see that kind of number, because if it doesn't work in the ordinary situation, the reverse journey is likely to definitely be very impactful. And I think, in all earnest, most of the institutions are very mindful about these things. It's just a few here and there which lag in their integrity, and which is why, unfortunately, the slowest of the herd defines the speed of the herd.
Yeah. And this 250 crore will become a weapon for compliance folks, right? Legal and compliance folks will use it
I hope not.
in,
I hope
in
not. I'm
their
just
discussions.
like, this is
Like,
also the greatest threshold in that it's not the first threshold, it's like the highest threshold. But I'm
it's
just
up to
saying that,
250 plus.
yeah, I'm just saying that, hopefully that should be a great deterrent instead of like 2,000 or 10,000 rupees for day of per day of non-compliance, the way we've seen languages in the older laws. I think this is
Yeah.
a significant change, and it's very mindful. And I'm so glad it doesn't talk of the GDPR global turnover aspect, because that, I think, is another end of the
Yeah.
spectrum. I don't know
Yeah.
whether that helps either, but this is very, very, very nicely done, and serves the context.
So is this 250 crore arbitrary as of now, right? Like up to 250 crore. So the board, the quantum of penalty will be decided by the board depending upon the breach, the matter,
The matter,
the
how significant.
consequences
I'm
involved.
assuming that there'll be a method to the madness. But what's good is that the ceilings are very clear. I am certain that at times, if there's a larger player which is found to be wanting, they may wish to set certain examples also. So I know that when two enterprises of different sizes are in front of the same regulator, more often than not, the regulator says that, listen, the bigger one has to lead by example.
Hmm.
So, which is what trickles into the industry, which is where the seriousness comes in. So, I'm hopeful that they will be very mindful of what they do. The idea is to initially, I think they would be a little liberal before they start getting very serious about it. I would want them to be serious from day one, but because it can't be taken lightly anymore, and we are
Anymore, yeah.
a large country, the size of our population, and in another 18 months the number is only going to increase, and
Increase,
it
yeah.
is that much more data which is right, from where the birth certificate, that data, everything is a data point. So we tend to talk of Aadhaar, etc., etc., but the fact is that every such data is a data journey. And then going to a school processing a data, that is also a data journey. You and I going to a hotel, giving our data,
Mm.
that is also a journey. We going to watch a movie, and will you be interested in XYZ? That is also a data journey. I just want to watch the movie. Why do you want to even push this to me?
Yeah.
It's like that.
Yeah, and like you beautifully mentioned, right? The next 18 months there'll be a lot more data added. So it's more of a it's only going to be a catch up, right, for most of the
Yeah,
institutions to
yeah.
comply to this.
It'll not be
Uh,
a catch up, it'll be an overall. Institutional level, the
okay.
traditional privacy notices, the traditional terms and conditions will cease to exist. There'll be meaningful notices given
Oh,
to you and I. It will be clear, it will be unambiguous, it will not be something. Of course, there's a positive affirmative action that, you are scrolling and I'm scrolling and we are then ticking. We all understand that. But the language will have to be crisp.
the
All
not
that,
notice.
the overdose of well drafted paragraphs by some people of my fraternity, I think will get reduced to single lines, which will be in bare minimal English, the way all of us understand, not only English, but all the scheduled languages. I'm assuming that that will also be very strictly followed. Because if I am expecting a particular service in a particular area in the language that it should be given to me, I can't expect the notice to be served to me in English. So that's also a very nice change. And thankfully, there are systems today in place which help us achieve that translation in a meaningful manner sooner than what it would possibly be done earlier.
Got it. Well, this is the example wherein there's a credit card holder holding a card of one card. It's a fintech. It's a co-branded
Yeah,
partner with the bank, and then there's a bank which is the main card issuer, and there is a technology service provider which is F2P. Now, where would you put in, data fiduciary, data processor, and like if you have to talk about, obligations, right? If you could use this example and give us a brief.
yeah, sure. The issuer would be the fiduciary because that's where everything is happening. That's where everything is culminating. It is the service of the card issuer that was sought for by the principal, which is this gentleman here who is showing the card. And routed through the co-branded partner who is a fintech who is using the services of the bank and only doing that part of the journey of onboarding the customer, and thereafter everything is the card issued is by the card issuer, and the TSP would be the another processor who would see the credentials of this person, the credit worthiness, the CIBIL checks, etc., etc. I'm assuming that's one of the parts that would be applicable, and to that extent, the service provider would be a processor, authorized by the fiduciary, which is the card issuer. To a limited extent, even the co-branded partner would be a processor for the onboarding part of the journey. And everything will sit with the issuer, who is the fiduciary. So, to my mind, the responsibility and all the actionables will be that of the card issuer. They, in turn, will have bilaterals executed with the co-branded partner and the service provider, the tech service provider. And in these agreements, you will see a lot of contractual rights that will come in this journey going forward.
Finally, in comparison with other privacy laws across the globe, uh, briefly where we stand, and I think if I were to put it, how quickly we can move to a regime of compliance, right, and be better than the global regulatory regimes.
I think as a country, we're very mindful. We are very clear of the perception that we wish to have. We want to also showcase ourselves as leaders. We want to showcase ourselves as very serious players in the global play yard, so to say. So to that extent, I'm most certain that we'll be very nimble-footed. We will get this into action very quickly. We took some time to, get this in place. But having got here, I am extremely certain and hopeful that we will be very quick in effectuating each aspect of this legislation, considering again that the individual protection is utmost importance. And thankfully, the nation is also very mindful of these aspects. And again, I go back to the UPI example. What we have done, we have revolutionized the whole concept of payment. And that is real time. I mean, I get your number or I get a QR, I scan it, and I can pay a vegetable vendor. I can pay someone who wouldn't have even contemplated. The first thing which would have come to our minds in that journey would have been that each one of us is carrying a credit card machine, that, I have to do a digital payment. For that to suddenly just vanish into just thin air and get represented into a a sticker sheet where payments can happen on a real-time basis is mind-boggling. And if we have achieved that, I don't see why we should not be achieving this, and this should be a simpler and easier thing to achieve. So
That is
thankfully, we
the
have kept it simple, which is, I'm sorry, I'm just taking one
yeah.
second here. We've kept it very simple. We have kept the customer, we've kept the data principle right at the center of this entire narrative, not called her a subject, which is something I find beautiful. I'm sorry, I'm going back right to
Yeah.
where we
No,
started
no,
from.
it's a very
And I
good
think
point, actually.
it's a beautiful piece. I think it's phraseology that somebody was very mindful and casting that fiduciary responsibility and that concept of entrustment and data being entrusted. So somebody needs to act very responsibly, possibly more than what even the law documents. So I think now that these pieces are there, we'll be very, very nimble-footed in turning this around. And I think there'll be a lot of support from the industry as well, because they will also be very mindful that if they go wrong in this, then there could be a larger impact. I mean, a traditional enterprise, if they're not, changing in this 18 months, they'll fall like a pack of cards, because you and I will be very mindful that going forward, and now that we have the protection of the law, that we share our data only with people who are serious about it.
Yeah, you correctly put it. Two things. One is the UPI example you used, right? There's an invisible flow in the backend, and that is something we will see in even in know your data journey. That flow,
Yeah.
coming into effect, right? And securing and being securing our data and becoming compliant. That is one. And two, uh, the consequences are will be felt. Clearly, all the institutions will have to spend more, on resources, and put in more funds, increase team size, right? The compliance cost is going to be increase. I think there will be a lot of discussions going now already taking place. How do we restructure the teams eventually? And come to a plan of compliance, right? So, so if the plan, if we talk about quickly about plan, which is my last right question. So first, it will start with a data mapping exercise, right?
Yes.
And then coming to formulating notices, right? And then sending out the notices to the data principals and getting their consent as per the notice, the purpose of the notice, and then implementing the flow. I know it's a very brief flow, but what do you think would be the next steps for
No,
most
you're right.
institutions?
And considering this law is that simple, I think these journeys will also be equally simple. But the only difference that I have is that these will happen parallelly and not one after the other.
Yeah.
The data flow mapping, I think each uh, consensus institution will possibly already know because everybody has a customer profile that more or less is there, and they reach out to the customer through various ways and means. All your cookie policies, all these journeys where you identify and you're able to pinpoint the customer, where is he or she onboarding, what was the point that they left. All these journeys are there, and mostly the larger institutions have these pieces in place, so I don't see too much
Okay.
requirement in that extent. To that extent, what really needs to be looked into are the the extremely humongous notices and privacy policies and terms and conditions, and something which is tucked into some corner, that how to opt out when you keep on searching URLs from here and there, and it'll just to show compliance. Yes, it is there, but hand on heart, does that really help a consumer? No, it doesn't. I think those are the things that will need to be ironed out. I don't see there's too much of heavy investment happening. To my mind, whatever investment will happen, and in case someone is very serious about this law and the implementation of this law, will humongously gain on the consumer confidence index. If
Yes.
a customer, you and I, if we are confident that we'll be treated well at a particular place, that is where the premium will also come in for that enterprise.
Yeah.
That if you and I are mindful that we need to, avail services from this one particular place because I know my data is secure there, I'll be happy to pay that delta extra. This is maybe very simplistic to say, but if that is the level to which organizations come, then largely the cost also kind of eases out. The long term, it benefits the organization for sure,
Got it.
because possibly you'll have the confidence of many more customers, and if that happens, it'll be definitely worth your while to put whatever that effort is required to be in compliance of this particular law.
And you would have already actually started these discussions with your clients, right? And giving kind of a direction as
Yes,
to how to
some
go
of
about.
my existing clients have known that I've been involved in certain
Mm.
aspects of this for some time, and yes, we have had some initial Kickstarter conversations already. So let's see. Uh, we have some time in front of us, and I hope it's a meaningful conversation that we all have. And as individuals, as enterprises, as advisors, all of us have to have a very meaningful, thought through discussion on the aspects of this particular law. And I'm very certain this is going to hold the country in very good stead, because somewhere the confidence of data within the
Yeah.
country will also rise. And that's a
Yeah.
wonderful narrative. That's a wonderful narrative in today's world, in the whole dark web, how data is just, going out and people are doing all kind of things. I think if again, sorry for repeating, if we could do UPI, I think we can do this
Yeah,
as a country, as a country. So
indeed, indeed. Well
KYD.
said. Yeah, yeah, KYD. That it's very interesting. Thing you have put it. I think for the first time,
No, I've said of this
public,
before,
or
and
you
it's
have
as
spoken.
simple as the law is.
Yeah, yes, indeed, indeed.
It
Great.
just gives the entire narrative. Please be mindful. That's it.
Thank you so much. It was very interesting and insightful conversation. I think we have discussed most of the aspects, right? And it will be interesting times to see. I can imagine like the dynamics would change a lot after 18 months, right? Across institutions, and concerned entities. So it'll be some interesting times to wait for. Thank you once again. Hope to discuss some other topic in future with you.
Certainly. Thank you for having me. And this is a topic very close to my heart. So I'm glad, I could share my views with you and we could have this conversation. Very happy to speak to you on this and looking forward for our next round.